Hello, all you Depuy, Pinnacle, hip litigation warriors out there. This is a special bonus episode coming to you on Tuesday, the 29th of October. And we're going to be talking about probably what I think is the most important topic of all of them. More important than the advances, more important than anything else, because I've been working on this all weekend, drawing out my brilliant outline for today's show. I'm recording it at night. And it's the topic. And it is, I'm writing a letter to my lawyer, and I'm going to go through it slow enough so that you can go through it with your lawyer. And let's send them a letter that gets them off the dime, gets them moving, although I'll probably say 100 times that doesn't prove that they would get an offer if there's not an offer on the table. And B, not only let's get them moving, but let's clear up a lot of these questions about what our options are. And I'm looking down at the end of the show, but towards the end of the show, we're going to be getting into a lot of, well, what if you don't live in Texas? And what if you don't want to go to trial in Texas? If you don't want to move to Texas, let's say your trial starts March of next year, and you don't want to spend 2 months living in Texas. Okay, what are we going to do? What are you obligated to do? What are you entitled to do? What do we have control over with Judge Kincaid? Remember, Judge Kincaid now has made it clear that after November 12th, something's happening. November 12th, he's supposed to have all of those damages in there, all of your specials, all of your bills that pertain to the treatment, the cost of your case, but he hasn't said what he's going to do with them, at least the last I heard. And so is he going to just put you back in line outside the Dallas courthouse? Or is what he's doing going to be, and this is my guess, just a guess, he's going to call in the lawyers on each of our cases and maybe do 50 cases a day and say, what is it that you're offering? What is your top offer? What is your bottom offer? Okay, I want you guys, here's where I want you to meet in the middle. All right, call your client and see if they'll take this much. Call Depuy and Johnson & Johnson and see if they'll pay that much. Settled? Not settled? I'm shipping it back to this one's Los Angeles. So you're going to go to federal court in Los Angeles, and you're going to have to be there on Monday. Now, I will tell you this. If he does that to your lawyer or my lawyer, they will shit a brick. Now, the one thing that you're asking, and I don't have the absolute answer to, is, well, are you saying that's because I theoretically live in Los Angeles, which I don't? Right. I do not know if he would ship our case somewhere where our attorneys aren't and we aren't, and say, well, I've got an open federal court in D.C., so that's where your case is going. I don't think they would do that. I think they have to send it back here to wherever it came from. But we're going to get into some of the strange questions that would arise if that happens. Let's just hope the money comes up. And more importantly, how can you use the threat of that coming up to get your attorney on the ball and to drive a harder bargain about what you're going to do about your fee? So here's where we're going to go. Now, first thing you want to do before you write your attorney a letter is you want to read your retainer agreement again. Usually might be one or two more documents with the retainer agreement that aren't very important. Those are things like releases you sign so that he could get a copy of the papers that you want him to be able to, and maybe some sort of a listing of what are your damages if you met with him and you signed it, and so that he would have a list that he could start working on to gather all the information. Usually sign that, don't sign it, doesn't matter. But go through all that, and then we're going to get to here's the letter. Okay, so I'll take a quick second here for you to sit down. We're going to start writing the letter. I am not going to tell you how to open the letter because I do not want you all using the same opening. We don't want the attorneys that are out there seeing that we're doing this as part of a movement. So You're open to the letter. Hi, how's it going? Dear attorney, I'm scared. I'm miserable. I'm happy. I'm so glad that you've done a great job. I'm so pissed off. I'm so glad. I'm so glad. I'm glad. I'm glad. Well, anyway, it doesn't matter. Just your own style, your own thing. Write the attorney an opening salutation, as we say in the law business. First, salvo, which for our non-military people, that's a blast of the cannons on the side of the ship. Miss Attorney, have you compiled a total of the damages, both special and common, in my case? Are you done adding up what are my damages? And those would be, special would be the ones like, the medical bills, how much have you spent on prescription drugs, on physical therapy. Also, then you want to get into things like lost wages. How much have you lost going to the doctor? How much have you lost being laid up by that lousy machine? And with that, we're going to ask about the very difficult calculation of, have you compiled for the court any estimations of the likelihood that I'm going to suffer future injury after this case is over in November or December? Have you come up with numbers so that I should be paid now in case I come down with liver cancer from the Cobalt appliance, the hip appliance? Well, you want to ask your attorney, what is does he come up with the number? Then when was that completed is very important. That is absolutely, as sure as shooting, the sign of what kind of attorney you've got. If it was almost done or done years ago, 3 years ago, 4 years ago, that's a very good sign. That means they've been preparing for trial all of this time. That's great. If they say, well, don't worry about it. We don't have to have it ready till November 12th, so I'm going to stay late on the evening of the 9th and get it done. Holy cow, you're in the wrong office. You're in the wrong office. So that would be a bad answer, but that would be one of the ones that you want to ask. And then, of course, this goes with what I was just saying to you. Has that been forwarded to the court? And I believe you want to ask, can I have copies of it? You're entitled to copies of it always. But attorneys will fight you to the dickens and come up with every strange story because they believe that if you're asking for copies, you're getting ready to fire them. That's what that means. And I'm not telling anybody to fire anybody. I'm just saying let's get ourselves in the driver's seat so we know what's going on, what do we got, and number 2. Did any medical records get reviewed? In other words, are they doing it like small-time law offices where just the attorney looks at the medical records and says, well, I'm practically a doctor myself. So I'm going to just look at it and I think that, I think this is what the case is worth. Is that what they're doing there? Or are they treating us good? Are they? Is this guy, has he sent it out to like an expert in jury verdicts? Maybe a medical expert who can go through all of the terms and all of the damages, in other words, the physical damage that they see inside of your x-rays or whatever tests you have, and can write up so that we both have a real good understanding of the medico-legal, that's medical and legal, facts of the case that prompt money. What part of your injuries are worth money to a jury and how much? And there are people that do that. Now, there are most attorneys that are cheap and don't want to pay an outside service to do that. Will say, I can do that. I've had so many. But they're not. They're not the same expert. I used to always, in any case that I figured was worth more than $100,000, I'd have one of these people come in. Sometimes they're former nurses, sometimes they're former attorneys, sometimes they're former both. And they write you up a nice report saying, here's what I see in the way of injuries, here's what I see as risks in the case, why they might not offer you everything you want, and here's what I think the case is worth. We can go from there to question number 3. Did you notice that my surgery, was set for so-and-so? Now, in other words, what you're asking the attorney in this case is, if you're going to be having surgery or if you had surgery, you want to see, is this person aware of the date of the revision surgery? Okay? Very important, because as you've heard the whispers that I've heard, Johnson & Johnson is talking about backing down. They're talking about saying, no, we meant we were going to settle only those cases with the revision surgery was within 10 years of the installation of the appliance. So we want to find out, does your attorney know exactly when your surgery was, if you had it, or if you haven't had it, does he know when you're planning to do it, or are you not? Now, me and you have talked a couple of times about the effect that, what about if our physician, the surgeon, if we think that it's partially her fault or his fault, shouldn't we have sued them too? I was walking around the first 5 years of this case thinking something's wrong. Why didn't this guy sue my doctor? Because my doctor must have done some bad installation, which I still think he did. But I then looked, like, as I've mentioned to you before, I looked through the pleadings in the court file, and no attorney is suing their doctor. I'm going to go through the reason why. It's long, it's complicated, but I'm going to try and make this simple so you can understand it. It is a simple case, a slam dunk case, to sue another party on a product's liability case. All you're suing is saying the product was put out, it was unsafe, and it injured me. That's it. A medical malpractice case is extremely difficult. You have to prove what is the standard of care, which means now you have to bring in a doctor who's willing to testify to the jury as to what it is your doctor should have done. And then you have to worry about, because your doctor's going to bring in an expert who says, oh no, what he did was perfect. Oh, so now the jury is trying to figure out what they're talking about. It goes back and forth, and you have a good chance of losing. So what our attorneys have done in group or en masse, they've said, well, why should we bother? We only get paid once. If we sue them for both product liability and medical malpractice, we only get one recovery, and the recovery is greater in product liability. So why don't we just give away our client's case? We'll forget about it. We will not sue the doctor. And we just will hope to our bippies that we will win the product liability case. There's another thing, a tribute to our lawyer's laziness, that says, remember, on the product liability case, once these people prove it, like the 5 attorneys that are up there now already, once they've proven the case, we're pretty much done. If they prove that the product was unsafe, which I think they have, according to the courts, well, so great. So we're just waiting to see how much money we get. But if we were all suing on medical malpractice, the fact that in their case they won doesn't do anything for us, because what each doctor does in each particular situation is different. So, and what that means is that our poor attorneys would actually have to work hard and prove your case, research it, take depositions, meet with experts, school themselves on the injuries that you've suffered, school themselves on the correct procedures as to what the doctor should have done in that case, go through all of the documents to see if the releases that you signed said, oh, that's part of the risk of the surgery, and you waive it, and you understand it, and you give up any right to sue. So, wow, that's a dragon hiding in the cave. So none of those attorneys did that. They said, we're just going to go the easy glide. We're going to let all of the 5 attorneys that have won go in there, win the case 3 times, and we're just going to draft behind them, which that's a racing term, mean the force of the wind coming off the car in front of you. You place your car in a certain way, and it pulls you. Your car doesn't have to do anything. You can just sit there and use the car in front of you's wind to drive right behind that front car. So that's what our attorneys are all doing, and then hoping to collect a big fee. if we let them do it, we are pansies. That would be a big mistake. That would be a terrible mistake.